What happens if my right to confrontation is denied at trial? I'm Appell's attorney James Wirth, and that is the question that we have before us today. So the right to confrontation, that is a constitutional right under the United States Supreme Court that says if somebody is making a claim against you, you've got the right to confront them at trial, meaning cross-examine them, ask them questions at trial. But it doesn't apply in all circumstances like my prior few videos talks about. But what happens when that right is violated? So the case that we're dealing with today is actually a case decided by the Oklahoma Court of Criminal Appeals today, April 27th, 2023, Charles v. Oklahoma, M 2022-174. And in that case, it's a domestic violence case where the complaining witness did not actually come to trial to testify. Nonetheless, hearsay statements from her were allowed in, and the defendant claimed, hey, I was denied my right to confrontation. And the court found for some of those statements that they should not have come in, that they were non-testimonial, and therefore he was entitled to confrontation. So what happens at that point? Well, first off, you want to have your attorney note an objection on the record. If someone's trying to bring in hearsay that violates your right to confrontation, you want to object and get that in the record. That didn't happen in this case. Nonetheless, you still have a right to confrontation. You can still address that. So it didn't get properly addressed at trial. The statements were allowed in. The person was convicted. So what happens then? They can appeal it. You have one appeal of right of a criminal conviction in the state of Oklahoma. That's to the Oklahoma Court of Criminal Appeals. And that's what he did. And then it gets evaluated. We have to determine, because there was no objection, we look at the plain error analysis. And the court found that this is a plain error. It is an obvious error because he was denied his right from, to confrontation on testimonial statements. But it notes, a violation of the right to confrontation does not require automatic reversal. It then goes to the second part. It says, because the error was constitutional, meaning confrontation clause, which is in the U.S. Constitution, we must determine whether it was harmless beyond a reasonable doubt. So first, the court determines whether it was plain and obvious because there was no objection made. And then we have to look at the harmless beyond a reasonable doubt standard. And we have to look at, if this evidence had not come in, is the court convinced beyond reasonable doubt that the person still would have been convicted? And if the court finds that they are not convinced beyond a reasonable doubt they still would have been convicted, then the conviction has to be overturned, and it has to go back to the trial court for a new trial where the confrontation rights are not violated. However, in this case, the court found that even if we look at the record and we take all of that hearsay testimony out that shouldn't have come in because it violated the right to confrontation, even if we take that out, we're still confident without a reasonable doubt that the person would have still been convicted. So in this case, they found that it was harmless beyond a reasonable doubt, and they maintained that conviction. If you're dealing with a scenario where your rights are being violated, you want to talk to an attorney. You want to do it early. You want to make sure that at trial those errors are objected to and that record is preserved. And you want to talk to an attorney privately and confidentially about your situation, not just listen to videos on the web. So if you're into those circumstances, you can contact my office. We can get an appointment scheduled for you. You can go online to makelawEasy.com.